Judecatoria against Judecatoria Arad, Romania.
May it please, my lords.
Just a second while we get our documents up on our screen, then I'll invite you to start, if I may.
Thank you.
Mr. Cooper, yes. Yes, that's okay.
Thank you, my lord. My lords, I appear for the appellants in this appeal together with my learned friend, Miss Mary Westcott, my learned friends, Miss Helen Malcolm Casey and Mr. Stefan Hyam appear for the respondent, Romanian Judicial Authority, the Judecatoria Arad of Romania, which in this instance is the court. My references to the papers will be, as the court has indicated, we were able to hear the appeal yesterday and took note of all of the indications of the court. And so the references will be to the electronic format pagination. I understand one of my lords is working from paper, and so thankfully the same electronic format EF reference will be on that hard copy paper. But I hope that works.
It should work as long as you refer to the volume as well as the page number.
Indeed.
Thank you very much.
And my lords, if I can just indicate at the outset the structure of my submissions this morning. Firstly, I propose to provide the court with a brief overview of the salient facts of the appeal with reference in particular to the originating European arrest warrant itself, it being the critical document in these proceedings, and then the additional first instance questions asked of the judicial authority, the issuing judicial authority provided earlier this month. Secondly, I will take the court to the history of the proceedings with reference to the key judgments of the appropriate extradition judge, district judge and the administrative court. Thirdly, I will refer my lords to the relevant law, the statute governing these proceedings, and secondly, the framework decision which the statute must conform to. Fourthly, I will deliver my submissions on the merits of the appeal and the point of law certified by Mr. Justice Chamberlain, followed finally by short submissions on the respondent's case. And our submissions are summarised at EF 37 at paragraph 33 of our printed case, and answered in the same sequence at the end of our case. So if I may start with a very short introductory overview, the focus of this appeal is the correct approach to the statutory entitlement to a retrial provided for in section 20, subsection 5 of the 2003 Extradition Act, which provides an unequivocal safeguard of a retrial for persons such as the appellant convicted in their absence who are not deliberately absent. The district judge at Westminster is required to decide if the requested person before him will be given the right on the criminal standard of proof. Section 25 only arose for determination after the judge answered the sequence of the previous two questions which led to it. First, the judge made the factual finding and ruled that the requested person was not convicted in his presence. That's section 20, subsection 1. Reference to the authorities here is EF 418, if my lords would like to bring that up. Secondly, the DJ found on the evidence that the requested person was not deliberately absent pursuant to section 23. So, having decided both those subsections 1 and 3 in the negative, under section 25 the judge must then decide whether the person would be entitled to a retrial. So the entitlement to the retrial must specifically belong to the defendant before the executing appropriate judge, as the Act defines him. The statute requires that the court must discharge the requested person if this test cannot be met. And so if I can invite my lords to refer now to the, well, but just before referring you to the EAW, can I just briefly refer my lords to the clear guidance from my Lord Burnett as to the importance of the EAW itself, emphasising cretu at paragraph 32. That's EF bundle reference 615. and it's paragraph 32, where the Administrative Court gave some very succinct and clear guidance in my submission, stating that the requesting judicial authority is expected to convey the relevant information in the EAW itself. If the information meets the requirements of Article 4A, that would provide the evidence upon which the executing judicial authority would act. And then, if I can now refer, my Lords, to paragraph 34 of the same judgment at Roman 5, the Court explained, whilst by virtue of Section 206 of the Act, it remains for the requesting state to satisfy the court conducting the extradition hearing in the UK to the criminal standard that one or more of the 4 exceptions found in Article 4A applies, the burden of proof will be discharged to the requisite standard if the information required by 4A is set out in the EAW. So the EAW here is at page 329 EF, and one sees here from 329 that it comes from the Arad Courthouse, Criminal Division, Department of Criminal Enforcement, the top left of the page. It's dated the 7th of May 2019. And we see from the third page of the translation at EF 331 that the Section 25, subsection 5 issue arose in this case in the context of the EAW failing to endorse or confirm at pro forma box 3.4 of the warrant that the appellant, quotes, will be expressly informed of his right to a retrial. And my Lords will observe that that is blank, not endorsed. And so box 3.4 is provided pursuant to the requirements of the framework decision, Article 4A 1D Roman 1. And I must confess I concur with Ms. Malcolm that the way in which this Article 4A is set out with the various sections and articles is slightly difficult to follow at first blush, but I hope I can assist my Lords with that. And so the provision is mirrored in the model form set out in the annex to the framework decision as amended by the 2009 framework decision, and that was the form in fact used in this EAW. And so my Lords will recall the original 2002 framework decision had a pro forma, at Annex A was a pro forma EAW form, and then the 2009 amendment to the framework decision contains a new form, which is what we see in this case. The court must take my submission that the EAW content at face value unless there is ambiguity or confusion, which the DJ and the parties recognised in this case there in fact was. And that's the...
So before we leave that, could you just help me in relation to page 332 of the EAW?
Yes.
And there's specified the legal pledges.
Yes. And so...
sorry, does the pro forma also have an entry for legal pledges? And where do we find the framework decision referring to legal pledges? What's the role of legal pledges?
Yes, and so, my Lord, first of all, can I refer you to page 508, or EF 508, which is where the amended new pro forma Annex A form is to be found. And my Lords will see there that by the point my Lord gets to that legal pledge, the form is in fact ended on this EAW. So this is not information not part of the form. So it actually comes in this EAW after the fact set out, starting at 331. And so the form itself is not inviting the issuing judicial authorities to provide legal pledges to answer my Lord's question, whereas the previous framework decision, which was amended, the 2002 decision, I can just show this to my Lords at this is at tab 2 of the authority, so it's page 490, it's Article 5. My Lords will observe there, Article 5, on the right-hand column of 490, the EF reference, where there was previously a provision which has now been deleted by the 2009 amended framework decision, which is Article 1. And the reference to the deletion is at page 508. So Article 2 at 507, the amendment to the framework decision, Section 1, which inserts Article 4A into the framework decision, and then from Article 2, and then goes to Section 2, which states at 508, in Article 5, Paragraph 1 shall be deleted. And so that was the provision that previously allowed for guarantees to be requested by executing judicial authorities from issuing judicial authorities in relation to retrial rights. And it was the reason for the amendment was expressly to abolish that provision because it led to confusion and different standards and different approaches. And so instead, the European law amendment provided for an exhaustive system which would be easier for everyone to follow with this new pro forma at page 508, which would ensure that everyone provided the same information in the same way. So I hope that answers my Lord's question.
Thank you very much indeed.
And
Just before we leave the arrest warrant, I mean, box 3.4 has not been crossed, which is obviously central in this case.
indeed.
Is there any relevance to box 3.2 having been crossed?
Certainly, my Lord, there is, yes. And so if I can just go back to that, page 212, 3.2 states, so the pro forma is endorsed as providing the judge at Westminster with information from the judicial authority that, in this case, this defendant or this appellant was aware of his scheduled trial and that he had instructed a lawyer who was either appointed by him or by the court, but in either scenario instructed by him, according to that 3.2. And then, my Lord, we'll see at section 4 of this same pro forma, just over the page, the model form says, if checked, the points 3.1b, 3.2 or 3.3, please provide information on how the relevant conditions have been satisfied. So how was he aware of the scheduled trial and how did he instruct the lawyer? And the information there is that the defendant, Mr. Merticariu, was not present in court during the trial. He was represented at the hearings by the public defender appointed by the court. So, in fact, regrettably, there was no explanation for why he deliberately absented himself. So it only really does half the job. But then, so the information was lacking there, and so that is why, to use the test of Cretid that we have here, coupled with the Form A, an ambiguous and confusing EAW that doesn't explain itself or clarify the necessary information to enable the relevant tests to be satisfied. And so the appellant submits that the judge at Westminster and at the Administrative Court, Mr. Justice Chamberlain, were wrong to decide that this appellant, on this available evidence, in this case, was entitled in Romania to a retrial, and that this issue should have been decided differently, the Section 25 issue, which would have resulted in his discharge. And I recognise that so as a matter of EU law, that the failure to endorse box 3.4 provides a basis under 4A framework decision on which the executing judge may refuse to surrender, can refuse to surrender. Equally, had box 3.4 been endorsed, the judge would have been required to surrender. So it is clearly intended to work both ways. Unlike in Cretu, on the evidence here, it could not here be assumed that Romanian law would provide this appellant a retrial. The judicial authority did not provide that evidence, or even the relevant Romanian law. We can nevertheless see from the law of Romania, Article 466, that it would in fact disqualify the appellant from a retrial. It's no procedural step, but a substantive determination of his right resulting in its denial, the denial of the right. And so if I can just now very briefly give my lords a short synopsis of the key facts, which are not in dispute in this case at all, but nevertheless important for the court to fully understand why the judicial authority in this case has not discharged its burden. So Mr. Merticariu, the appellant, was convicted and sentenced to 18 months immediate imprisonment in his absence in January 2019. The offence he was sentenced for in absence relates to theft of tools from his former employer's car wash to the value of €1,500 in March 2016. The Court of Appeal in Romania upheld his conviction and sentence in April 2019, which was an equivalent scenario to that in BP. And the EAW was issued the following month in May 2019. In summary, the appellant is a relatively young man of otherwise good character with no previous convictions in either Romania or the UK since 2016. So no convictions in the UK since 2016, but no convictions anywhere. I should be clear, but he's been here a long time, working hard with a family. He turns 33 in February of this year. He was arrested on this EAW in September 2019 when he was 29. The judge found he wasn't a fugitive. There's no suggestion he was. He's been on conditional bail since the start of the case with a nightly curfew and daily reporting to the police station, only just recently lifted. And then can I now just take my lords to the proceedings before the appropriate judge at the Magistrates' Court. So the full extradition hearing was on the 21st of August. The appellant, and this is important and different to the case that my lords heard yesterday, the appellant gave evidence before the DJ that he was not aware of the trial date. His evidence was not challenged by the judicial authority. In fact, the DJ recorded at his judgment, this is page 140 of the bundle, paragraph 15, that it is accepted under the heading section 20, trial in absence, deliberate absence. It is accepted that the RP was tried in absence. The only evidence from the JA that relates to whether the RP was informed of proceedings is in box 3.2, which reads, being aware of the scheduled trial. No evidence provided on how the RP was purportedly informed of the trial. The JA do not appear to be arguing that the RP was properly informed. And I submit, as an overarching submission to understand the coherence of the statutory scheme, that it's significant that the issuing judicial authority is party to the determination of this issue before the judge. It brings the proceedings to the court and provides the evidence on which the judge determines these issues. And that's relevant when one considers what would happen after the event post-surrender. So the judge... So what was missing then from the judge's exercise was evidence establishing section 25. The previous sections were uncomplicated. What followed were multiple attempts to answer the relevant statutory questions before the judge. There were some initial delays at the outset of the magistrate's proceedings after the initial hearing. After arrest, he was brought before the court on the 26th of September 2019. I understand between November 2019 and February 2020, the appellant was unrepresented. There were problems in that regard. He was represented, in fact, by a firm whose extradition department has since closed. Regrettably, we don't have those records. But what we do know, and we're grateful to the respondent for clarifying the factual position in this month by means of the further information. We know that there was an adjournment of the extradition hearing when it was first listed on the 25th of February 2020 on the application of the CPS, or the judicial authority, for it to make a request for further information, as it's known, the RFFI in summary, about the appellant's retrial rights, because this was not clearly set out in the AW. See bundle page 385, where that is all confirmed, the source document. And then on the 18th of May 2020, the CPS made a RFFI which led to a partial reply. So it correctly identified what was missing in the RFFI sent on the 18th of May 2020 in a document entitled RFFI, the CPS explained the EAW did not identify the appellant's right to retrial, and so asked the judicial authority itself, using emphatic bold font in its email, please can you confirm if he has a right to a retrial? That's at page 374 of the bundle. And the RFFI highlights the contradictions in the information provided by the judicial authority, noting that the EAW states the RP, the request person, was not present at his trial in Romania, and that box 3.4, which relates to the right to retrial, has not been endorsed. It therefore cannot be said, and this is to quote them precisely, cannot be said that...
Where are you reading from, please?
I'm so sorry. This is at page 374.
374.
Yes. Yes. Yeah, so it therefore cannot be said that Ms. Merticariu has a right to retrial. Please can you confirm if he has a right to retrial? Please reply by the 19th of May. Yes, do my lords have that?
Yes.
Thank you. And I should highlight that the RFFI also explained to the judicial authority the express statement in the Form A. Can I just refer my lords to the Form A briefly, which is...
I'm so sorry. I've not... Oh, yes, I now see where you were reading from. Yes.
Oh, great. Well, my lords, the Form A is EF, page 320. And my lords may be familiar with the Form A as being supplementary information pursuant to Article 26, SAS, which is the document that supports the provisional arrest of a requested person. It's the alert that allows for Section 5 of the Extradition Act, the provisional arrest to take place. And then the EAW must be served as soon as practicable thereafter. So Section 6 of the Extradition Act says that the defendant must then be produced before the court in 48 hours. So it's really the document that enables the police to execute an arrest. And one sees there, my lord, that this document provided to the appellant with the EAW at the start of the proceedings is endorsed to assert at bundle page 321 that there was, quote, a summons served by other means. Do my lord see that? It's the second main box, second main section on page 321, with the number 297 after it, and there's a cross endorsing summons served by other means. And then, so the contradictory assertions require the CPS to seek further information beyond the EAW as envisaged in cases of quote, ambiguity or confusion, as described in Cretu at paragraph 35. In this same RFFI, the CPS advised the judicial authority of its general duty of disclosure in its common ground that the duty of candour extends to, quote, any information held in the requesting state, as it explained, which is why the CPS invited the judicial authority, quotes, to consider whether any such material exists that ought to be brought to our attention. That's page 375 of the bundle. So the CPS sent the RFFI to the Romanian liaison magistrate as, quotes, an urgent inquiry by email, explaining, quotes, that it's one question should be quick and easy for the IJA to answer. The liaison magistrate didn't reply to the question posed, but instead, on the same day, 18th of May, sent provisions of the Romanian Code for Criminal Procedure translated into English. And that's page 378. If I can just refer my lords to that. One sees there the Romanian law. These translated provisions at 378, 381 were not served or advanced at all by the CPS at the magistrates or the High Court appeal stages of the case. So instead, the respondent's case before this court simply cites Article 466 and 467 to 470, but without any comment from anyone on it. The appellant, for his part, served a translation of 466 before the High Court and this court, which is at authorities page EF 2528. Instead, the approach taken by the judicial authority before the judge was to rely on the citation of the law from BP in Romania, which is at page 594, paragraph 38. The Romanian law made available by the appellant is said to be correct as of 7th of February 2014, therefore predated the 2016 directive the respondent places reliance on. And so...
What page number was that you just referred us to?
I'm so sorry, that was 594,
594.
paragraph 38. And so it predated the directive and the directive's transposition deadline of the 1st of April 2018. The transposition notification, and the reference to that is page 372 to Roman 1. The transposition notification was not in fact made until 29th of January 2021, bundle page 372 again at Roman 6. So very briefly, if I can just observe that the reliance by the respondent on foreign law from another judgment of the Administrative Court was contrary to the guidance of the Administrative Court in Kotsev, where the High Court warned that, and this is bundle page 1337 at paragraph 52, where the High Court warned that, quotes, district judges should not attempt to decide questions of foreign law for themselves unaided by any assistance from the issuing judicial authority, especially when dealing with the, quotes, notoriously difficult topic of retrials. There has been no assistance provided by the judicial authority in this case addressing 466 of the Romanian Code, still to this day, and the appellant submits that foreign law must be interpreted with caution, relying on another judgment of the High Court of Dobrowolski in Poland at bundle page 1134, which we have addressed in our case, bundle page 52, paragraph 78, 79. So it's not a reliable source for an answer to be for an answer to a fundamentally important question such as a retrial question, which is a notoriously difficult question in the view of the High Court. So if I can then...
the document you took us to, the at page 320, that came with the arrest warrant, does refer to Article 466 in terms which I don't think are controversial. It says, according to Article 466 of the Romanian Penal Procedure Code, the subject has the right to ask for retrial of the case.
Yes.
I mean, your argument essentially is that a right to ask is just not good enough.
Exactly, my lord. Yes, and I was intending to refer my lord back to that passage in due course, and so that yes, absolutely. That this emphasises it's not a right to a retrial, but a right to ask for a retrial. Yes. And the amendment to the framework decision expressly changed the law from the right to ask for the retrial to a simple right to the retrial itself. And all of the supporting documents analysing that amendment and that progression of the law show that it was a deliberate decision intended to enhance the protections of defendants in these circumstances, and that this whole 4A framework decision regime was specifically focusing on this stage of the proceedings, a surrender stage, as opposed to any domestic law that follows, to harmonise the approaches to surrender, to ensure consistency across the European Union to this very issue.
Let me put simply, your case is that Section 25 says what's on the can.
Yes.
That there has to be an entitlement.
Yes.
And also that if you have to go, if the requested person is sent back to the requesting state and has to apply, and the courts of the requesting state have to reconsider what the requested state's judge has already considered, then you say that doesn't meet the requirements, and that the various protections that the ECHR and EU law confers are in a sense beside the point, because the factual issue is being redetermined.
Exactly, yes, and I submit that it matters, and it's significant that essentially it's the same that the judicial authority was a party before the proceedings, before the court that made the decision. It supplied the evidence, and it is it must be wrong for that party to seek to persuade our judge of one outcome, to be fully involved in that decision with evidence and submissions, and then somehow to go behind their back and seek the opposite outcome.
Redecide the matter of new.
Yes, so it's a question of basic fairness, that one needs consistency and finality to that issue. One doesn't reopen the same issue, redetermine it, reassess it, and And the whole point of this form and all of the law is it's a binary question that's been posed, and the form and the system is designed to simplify it, and they obviously have that information readily to hand at that pre-surrender stage to ensure that the issue is properly resolved. Then one can't have a judge saying, I decide that you will, on the evidence before me, you will be entitled to a retrial, and then the judicial authority expressly seeking a redetermination, revisiting that very same issue.
If that were done in our courts, it would meet a plea of abuse of process. And indeed, in the abuse of process jurisdiction, if it had been determined by a foreign court and was sought to be redetermined in our courts, that would be an abuse of process as well. In other words, the domestic doctrine of abuse of process looks at coherence across the law between states as well as within the state. Absolutely, yes, and there's clear authority as to the correct approach to abuse of process, and one of the examples given is that if a judicial authority or government brings an extradition request, knowing that in fact it's unsustainable, that it shouldn't be seeking to persuade our judge here to the contrary. And so there are standards of consistency expected of requesting states and requesting judicial authorities, consistency between our courts and the source of the request. And they are obviously best placed to have the relevant simple material. So, my lords, if I can then just try and complete this exercise to ensure you have the full factual picture. So the 20th of August 2020 was the next stage of the attempt to get the missing information from the judicial authority, which was in fact the day before the listed extradition hearing. And the CPS sent, quote, sent officials in the MO, this is page 373 of the bundle at Roman 3, CPS sent officials at the Ministry of Justice in Romania, the RFFI, the translation and the EAW, with an email asking, quotes, whether the requested person will have a right, the right to a retrial, and added that beyond the Romanian legislation, we would like a specific response to this requested person's individual rights, as it is not clear from the EAW. So they couldn't have been clearer as to what the problem was and how it was to be resolved.
Sorry, this is page 373.
This is now page 382. I'm so sorry.
Please, if you're reading,
yes.
If you refer us to a page and then you read a passage from a different page, let us know. 382.
So I'm so sorry. So I was referring, my lords, first to the 373, and then I moved on to 382. So the quote. Do my lords have 382?
We would like a specific response to this requested person's individual rights. Yes, thank you very much.
Thank you, Miles. So, in the absence of any further information, at the effective extradition hearing, so just to explain, there was no reply to that request at 382. So, in the absence of any reply at the effective extradition hearing on the 21st of August, the respondent submitted that further information was not required, as the EAW was sufficient to answer the Section 20 questions. So the hearing then concluded, adjourned for judgment on the 1st of September 2020. But then the judgment didn't happen because on the morning of the listing, on the 1st of September 2020, the judge emailed the parties to state, and can I give you the page reference before I quote it? So it's 385 of the bundle.
Yep.
This is the beginning.
Yes, and just to take to the, it's because it's in reverse chronological order, I think. So it starts at 386, and one sees that 943, Judge Ezat, to Mr. Almaz was a solicitor acting for the appellant at the time. He says, I'm not going to give judgment in this case today. I'm going to ask the JA for further information about the retrial rights of your client. I will then give you an opportunity to make representations on the point if you wish. The client need not attend. If you're able to catch him before he heads off, that would be appreciated. And then one sees the response from Mr. Almaz is, thank you for letting me know. The case was adjourned for this purpose in February. No information was forthcoming at the last hearing. Mr. Hyam Do my lords have this? 385, this is 385 in the middle of the page. Mr. Hyam and the JA take the position no further information is required. I just wanted to check you were aware of this. Should I still attend it too? The judge says, Mr. Almers, thank you for the information. I would still like further information from the JA. You need not attend this afternoon. I will email you with some new directions later in the day. And then at page 384, going backwards, see the sequence of replies. Mr. Hyam explains that, well, he simply asks for clarification as to whether it's the judge is making the request himself. Article 15 of the original 2002 framework decision allows, so Article 15.2 enables the judge to make the request himself. And Mr. Hyam was just checking whether this was a further judicial authority request under 15.3, and he confirmed at page 383 that the request was being made by the court itself under Article 15.2 of the framework decision. I don't know whether my lords would appreciate me would like me to take you to Article 15 of the 2002 framework decision, which gives the power to request this information from the court. But maybe I'll just give you the page reference. It's page 492 of the bundle. If Article 15, surrender decision, Section 2, if the executing judicial authority finds the information communicated by the issuing member state to be insufficient to allow it to decide on surrender, it shall request that the necessary supplementary information, in particular respect of Articles 3, 5 and 8, be furnished as a matter of urgency and may fix a time limit for the receipt thereof, taking into account need to observe time, so on. So the judge directed that it be served by the 22nd of September. Instead of, that's at 384, instead of this being a further ask, and I've explained that he clarified the source of the power, the request wasn't then transmitted until 2342 on the 21st of September. That's page 373 of the bundle, with an apology for the lateness, but requesting an answer the following day. We then have what was finally served, which was relied upon by the judge, and that is at 353 of the bundle. So it's dated the 24th of September 2020. Could I invite my lords just to turn that up, please? The 353. So dated the 24th of September, sent after the final hearing was sent with a blank email. So 389 is how it was received. That's the blank email. And what it says is, regarding your message, do my lords have this now? Thank you. So we specify that in accordance with Article 466 of the Code, the convicted person may request the reopening of the criminal proceedings under the conditions of 466, paragraphs 1 to 4. And then in the case of the trial in absence, the convicted person based on 4663, that is then quoted, and that's just about the time being all run from when you're brought to the country. Yeah. And you see from that what was not provided was 466 1 and 2, which is how, in fact, the Romanian court, on the existing information before this court, would have to refuse the application for a retrial. So the real point, my lords, is this further information did not answer the simple question posed by the DJ or by the CPS repeatedly to confirm that the appellant would have a right to a retrial. Instead, it simply said that he may request the reopening under particular conditions, but the request will be contingent on those conditions of 466 being met, and we know they wouldn't be, in fact. And can I just
you mentioned paragraphs, did you say 1 to 2 of the Article 466? Have we got that in an English translation?
Yes, my lord, we do. And quickest place to take you to it is just It's page 378.
So I think you referred us to that.
I'm so sorry, my lord.
Yes, you referred us to that earlier, I think.
Yes. And this is a document that was supplied by the judicial authority in Romania, but not relied upon before the court by the CPS at all.
I think
but it does show.
In a sort of aside, you said, but subsections 1 and 2 clearly show that he didn't have a right to retrial.
Yes.
Is that what you said?
Yes, and I'll come back to that, my lord. But it's explicit. It's explicit from 466(2) that he would be disqualified.
Yes, what you're saying is that given the earlier answers in the EAW as to the fact that he had a lawyer and so on, that he would be disqualified by 4662.
Yes, it's very clear. So 1 explains that it's only the person with the final decision who was tried in absentia who may apply for the criminal proceedings to be reopened. And the definition of tried in absentia is, firstly, the convicted person was not summoned to appear in court, and has not been informed thereof in any other official manner, respectively. And then if you and the person who, even though aware of the criminal proceedings court, was lawfully absent from the trial of the case and unable to inform the court. And then the next one, which also applies to him, is the convicted person who had appointed a retained counsel or representative shall not be deemed tried in absentia if the latter appeared at any time during the criminal proceedings. Well, we know that, according to the judicial authority, they did appear, and an appeal was lodged by that same lawyer. And so he's disqualified on those two bases. And so,
but just in terms of what evidence was before the district judge, was it the most up-to-date information? Was that at page 353? Is that right?
that was all.
That was all.
Yes.
So that was the evidence.
Yes. So not the bit I just read to you.
No.
But obviously the judge relied on the case law. But I've made my submissions as to when that can be properly and appropriately done, and the fact that the judicial authority itself didn't supply it, nor did it assist the court with the foreign law. And as my Lord Burnett observed in Cretu, foreign law is a matter of fact, and that's why assistance is required. So
if you're moving on from the facts, could you clarify something for me, which is I think I know the answer to, but I'd just be grateful for your
yes.
Answer. The box 3.2 was ticked.
yes.
And the information provided at the end of the relevant section was inadequate. Okay? And so, therefore, as you've submitted, the underlying correctness of the assertion in 3.2 became capable of being at large.
Yes.
Something seems to have happened on the 20th of February, which resulted, this is at the first hearing,
yes.
Which resulted in the 3.2 argument almost being thrown away because there was no effort that I found to get further information about the 3.2 point, which would have been the more obvious course. And you've taken us to what the district judge said in his judgment about the judicial authority not appearing to suggest that
yes.
the requested person was served. Could you just clarify exactly how that evolved?
Yes. So the judicial authority's case before the court, and obviously they have all of the relevant evidence in their possession and need to be clear as to what their position is. Given that, confirmed that it did not contend that this appellant was deliberately absent from trial. And that was because it lacked a sufficient evidential basis to establish that to the criminal standard of proof. And so the judge recorded that. But then what's significant is we also have the judge has to take account of the judicial authority's evidence, but also the requested person's evidence. He gave evidence, and his account was accepted both by the judicial authority and by the judge that he was not aware of the trial and not deliberately absent. And so there's a factual finding in this case in the defendant's favour that he is not deliberately absent, which is categorical and final. And the case law, such as Eason, confirms that that a party has to put its case if it contests a factual matter such as that, and a failure to do so is determinative of that point. And so there is no, as Ms Justice Chamberlain and the DJ confirmed, that there is no issue, factual issue as to that in this case. But my Lord is quite...
It may be that I just put a marker down for Miss Malcolm. In the notice of objection, Miss Malcolm refers to a concession made on the 27th of February 2020 in relation to this issue. And speaking only for myself, I'd be quite interested to know precisely the terms of that concession, if anyone has them.
Yes, and my Lord, perhaps to put it another way, the Council, the CPF, the Judicial Authority, was in fact in no position to do anything other than recognise that he was unable to meet the relevant test of Section 206, a criminal standard of proof, that there was insufficient evidential basis to even attempt to get that submission off the ground, because point 4, the pro forma, which was intended to clarify 3.2, simply didn't do so. It didn't provide the necessary clarification, and as all of the judgments have accepted, it's the EAW that has to be clear, and it's a simple process to complete it. I hope that answers my Lord's question. I just wanted to, in relation to what we do have from that further information, which is the 4663, as I observed, that simply explains that the time frame runs from when the requested person receives a judgment of conviction post-surrender. And the only factual evidence pertaining to this case supplied by the Judicial Authority, and this is important in my submission, any factual evidence addressing the facts of this appellant's participation at his trial was contained in the EAW itself. So the further, and this really addresses my Lord's point, the further information didn't expand on that or address it any further, and there were multiple attempts to seek clarification. And so all we know is what is at 3.2, which is that he was aware of his scheduled trial in instructor law, and that disqualifies him from 466 retrial. So it's important in the end to recognise that the decision not to endorse box D on the EAW as applicable to this appellant remains uncorrected, remains unclarified. There's no alternative evidence from the further information of the September or any other evidence. And so the evidence falls short of the Section 20 statutory test, and also the requirement clarified in Article 4A, 1D, Roman 1 of the framework decision, that he will, quote, be expressly informed of his right to a retrial. That's what was missing. And that was the language that was specifically brought in to enhance procedural protections of defendants in this situation, and simply wasn't satisfied. So in the end, it is a very simple, as my Lord Hodge said, this is a very simple case, because the evidence is very straightforward. It's not in dispute, and the evidence simply failed to establish a right to retrial. Didn't come anywhere close to the criminal standard of proof in my submission. So, my Lords, can I then just refer my Lords?
Can I just what's slightly puzzling me is, I'm back on page 378. We now know whatever information was provided to the district judge, that it's absolutely clear, is this right, that there is no possibility of a retrial for this person?
On Romanian law, it would be unlawful to afford him a retrial. It would be expressly contrary to the...
So it's not as if there's some, conceivable problem. It's absolutely clear-cut that he cannot have a retrial. Is that right?
Exactly.
Well, what about Article 6 in Romania? And before you make such a bold submission, does that not apply?
Well, Romania is signatory to Article 6,
Yes.
but that's not an answer to whether it, in fact, provides an effective Article 6 remedy in practice. And the case law is clear from the case of Buller, and even more recently in the judgment of this court in Popovic, that one has to consider the actual practice of convention rights being made effective and provided to defendants. And it's not enough simply to be able to apply to the European Court, because the remedy is too distant. Here it's an 18-month sentence. He arrives in custody. He's surrendered in custody. And that's why the protection has to happen here at this stage. And that's why that's the basic answer to my learned friend's submissions, that the whole point of this new framework decision is to focus on the correct approach in an exhaustive, to use the language of the CJU that it repeatedly uses, an exhaustive, tailor-made coherent system for the surrender arrangements itself. And so that, on one way of putting it, the damage will already be done if he had to invoke Article 6 in Romania. And there isn't any evidence in any event that would be properly. What one sees is, in fact, that the domestic law would stop that remedy from being afforded this defendant on the facts of this case. And so the judge.
Presumably, we don't have any evidence about how, in the law of Romania, convention rights either are incorporated into that law or are not. How they're given effect, if they are given effect, we just don't know.
No, that's right. There wasn't that assistance provided to the court, first instance, or an appeal. And so, in my submission,
you referred to Popovic and for the proposition that one has to consider the actual practice of convention rights. Is that authority in the papers, and if so?
Yes, we provided, yes, because it's a very recent judgment of this court. We provided it in the reply authorities. Yep. And it's page 29 of the reply authorities, tab 2 in my Lord's hard copy bundle. And we've highlighted the relevant passages, page 65, the final page of that ruling. But it's well-established law from the case of Buller, which was also a retrial, trial and absence judgment, that it's not enough just to look at the black letter law. One looks at how it operates in practice and whether it works and whether it provides an effective remedy. And so I was going to take my lords to the judgment briefly of the district judge, which I've referred you to briefly. Yes. Or perhaps I can just.
Your case doesn't depend on any conclusion that Romania might not apply Article 6, because, as I understand it, the mischief is that the Romanian authorities would be reconsidering a question which had already been determined by the British judge.
Yes.
And if the Romanian authorities were allowed to do that and were to decide that he had appointed a lawyer contrary to 466, and therefore bringing himself within 4662, therefore he wasn't entitled to a retrial, that wouldn't necessarily involve a breach of Article 6. Your complaint is this matter is to be determined in the requested state,
yes,
and that is conclusive.
Yes, and the judicial authority should simply bring its case properly before our court.
Yes, and you say that's consistent with the emphasis on looking at the arrest warrant and abiding by its terms.
Yes, and our judge wants to know categorically, to comply with the statutory obligation, whether this person will in fact have the right protected by Parliament and by the new framework decision and Article 6 and the directive and so on.
Yes.
All of it helps, all of the provisions end up helping the defendant, in fact. And so, my Lords, Mr. Justice Chamberlain, in fact, analyses at page 128 of my Lord's bundle. He does a very short analysis of the district judge's judgment. It starts at page 127, in fact, paragraph 16. I don't need to think I've made these points already. Paragraph 19, Ms. Justice Chamberlain explains, this is 128, bundle page, the district judge accepted that the further information, quotes, could have been more helpfully phrased, but found Mr. Hyam's submissions to be of significant assistance. He then cited a passage from Cretu, in which the divisional court said that it was, quotes, common ground that Article 466 of the Romanian Code of Criminal Procedure was introduced by way of amendment, transposed into Romanian law the relevant parts of 4A. It can be assumed that the Romanian law will provide the right to retrial in appropriate cases. And so, yes. So that the district judge, therefore, found that this was an appropriate case, and when in fact it's clear that Romanian law will disqualify him from the retrial based on the only available evidence. So he's not, therefore, upholding the defendant's statutory protection or honouring the language of the Act in deciding that Romania can refuse his right to retrial post-surrender if that is what it then deems appropriate later on. That is short of the right promised. So, therefore, in my submission, there was a failure to apply the statutory test. And Cretu itself was, in my submission, misquoted or misapplied because Cretu was predicated on an EAW that ticked box 3.4 and so provided the necessary information. If I just refer, my lords, to paragraph 42 of Cretu. One see here...
sorry, which page?
Sorry, I'm so sorry, it's page 618. And after dealing with the BP decision at paragraph 41 and the appellant's submissions, the court states, this, 42, this submission illustrates the type of dispute which Article 4A of the framework decision is crafted to avoid by requiring the condition which removes the discretion to refuse to execute the EAW to be judged by reference to a statement in the EAW. We are being asked to determine the meaning and effect of a piece of Romanian legislation, which in English law is a question of fact rather than law, by reference to little more than its language alone, in a way which contradicts a statement in the EAW. Well, there it was the appellant seeking to do that. Here, it's obviously the respondents, the judicial authorities, seeking to do that. And so this disapproval really applies, in our case, to the judicial authorities' submission. Once again, in my judgment, the statement in the EAW must be taken at face value, sufficient to satisfy the requirements of both Article 4A. So that's what the court was saying. That in that case, it was straightforward. The scheme was operating as it was intended. The box was ticked. It said a retrial would follow. There was no proper basis to seek to go behind what was a clear promise, an undertaking given by a judicial authority solemnly to our courts, that this is what it could depend on, this is what would follow. And that's what's missing here. So then the court goes on to say, that said, it is common ground that Article 466 was introduced by way of an amendment to transpose. And so I've taken my lords to this already. So that's the context in which the court assumes that Romanian law will provide the right to trial on the premise of the express factual promise on the facts of that case. And that's really where, in my submission, the district judge went wrong and the High Court went wrong in this case, because our facts were entirely different. And it wasn't a general statement of approach just to make assumptions about foreign law as a matter of general course, but it was where the evidence is properly made out, then one can make an assumption because they fulfilled their obligations with the pro forma. And so the judgment of the administrative court, and so the same point really applies. But what's interesting about the judgment of the administrative court in this case is one detects a very clear unhappiness from Ms. Justice Chamberlain as a single judge in the administrative court, feeling that out of judicial comity he has to apply BP. But as I hope my lords will see, as a matter of fact, in this case, BP is distinguishable, and he didn't have to apply BP. But in any event, BP took a wrong turn, as I'll come to submit in due course. This is yes. Ms. Justice Chamberlain therefore agreed with the district judge that the appellant was not deliberately absent from his trial, and accordingly he was entitled to a retrial. That's 16 to 17 of Chamberlain's. Sorry, page 127 of the bundle. The decision also recognised.
So what page number? Sorry.
I'm sorry. Page 127. So the judge. Yes, the decision of Ms. Justice Chamberlain recognised the judicial authority had advanced at box 3.2 an assertion of deliberate absence by the appellant from his trial in Romania. Chamberlain J therefore correctly focused on the EAW itself and recognised, and quote, this is paragraph 18 of Merticariu, number 1, judgment of Chamberlain, recognised, quotes, that it clearly showed that the appellant would have the right to a retrial. So the judge, Ms. Justice Chamberlain, in focusing on the EAW, recognised that the warrant failed to clearly show the appellant would have a right to retrial. This is important in my submission as it marks the appellant's case out from the case of Cretu and those which followed it, where the EAW was both unambiguous and sufficient as an evidential basis to provide the necessary clarity and certainty. See Cretu, paragraphs 34 and 35. So after summarising Mr. Malcolm Hawke's submission at paragraph 21 of his judgment, bundle page 128, Chamberlain J observed that his submission had, quotes, considerable force. The force of that submission is what brings us before this court today, and it was because the EAW did not show that the appellant had a right to a retrial, and nor did the further information provide the necessary certainty. The court caveated its view on the merits of the appellant's submission at paragraph 23 by observing it was subject only to two authorities against. The court noted at 32 that if the divisional court's decision in BP is correct, it undermines ground one against the appellant. And the judge ultimately felt there was no distinction between the instant case and BP, and that he was therefore bound as a single judge by judicial comity to apply a judgment of the divisional court. But it's plain from his reasoning the court doubted the correctness of the judgment it felt bound to apply. And this is page 131, I'm now taking my lord's. Chamberlain accordingly applied the divisional court decision, which found that Article 466 met the statutory test without recognising the very different facts that meant it couldn't properly be applied to give this appellant the necessary standard of statutory protection that he was entitled to. However, the judge recognised the basic problems of the situation by certifying the point of law, listing a hearing to determine the parameters of a point of law, general public importance, which she decided to certify. And the court has the benefit of the transcript of that hearing. It's key documents, tab 7, 3369. The back of the key documents, or electronic, simply 3369. And the court's decision at page 119, after the respondent's opposition to certification was fully argued.
So, I mean, you're racing through page numbers. Could you?
I'm so sorry.
Could you take us over them again, please?
Yes. The transcript of the hearing of the certification of the point of law is at page 3369, my lords. And if I can just give my lords one.
I may be getting ahead, but can you just answer this question? If we were to be with you, do we overrule BP?
Well, I was just about to take my lords to the facts of BP, if that would assist at this point.
I'm going ahead. That's fine. If you're going to deal with it later.
I do submit that it's not it took a wrong turn, as one says, in terms of its analysis of the law. But in any event, In any event, this case is distinguishable from BP when one considers the facts. But I will come to submit it took a wrong turn. But I just thought it may assist, my lords, to look at the page 3. The transcript of the certification hearing is. I've just taken, my lords, and one example is at 3373, and it touches on the point my lords have focused on just now. So 3373 at F, Ms. Justice Chambers says, but the real question here is who decides the question of deliberate absence, because on one reading of section 20, Parliament has actually been very clear and very straightforward. It is just said, you, the appropriate judge, the district judge in the Westminster Magistrates Court, have got to decide 3 things. 1, are you sure the appellant was present? If not, 2, are you sure that he was deliberately absent? If not, 3, are you sure that he would be entitled to a retrial? And on one view of those 3, Parliament could have said, are you sure you would be entitled to a retrial subject to the satisfaction of certain factual matters in the receiving state? It did not say that. It just said, are you sure that he would be entitled to a retrial? So on one level, Parliament was here conferring rights which go beyond what the European law provides. And Ms. Justice Chambers was exactly correct in that, because that's what all of the EU materials demonstrate, that Parliament was well ahead of European member states' practice and governing law in conferring this right back in 2003, which it then took until 2009 for the EU law to catch up on. And the UK is on record as making plain that it intended that stronger protection, as contended for by the appellant, which wasn't satisfied by the judgments in this case. And so And so, if I can, would it assist at this stage if I just took my lords to the key section 20 in the authorities, which I don't think the court has focused on so far, and it's at 418. Where it's set out, and the submission from that is that there can be no doubt as to the plain meaning of the statute, and that was the test applied by the court in Creti when interpreting the statutory language. The Romanian judicial authority, as opposed to the request, the burden of proof is section 206. Which has been referred to already, and the standard of proof, 206.1 and 2, that's page 483. And the reason the judge must be satisfied the person will be entitled to retrial is because to get to section 25, the court is required first to determine for itself that the person was not deliberately absent from his trial, and so must be entitled to a retrial. And so he cannot, therefore, when one looks at the statutory sequence of questions, he cannot defer that decision to the trial court. It is his judicial responsibility to resolve that factually at the pre-surrender stage. Parliament expressly required the judicial authority to prove that fact to the criminal standard. That's why it doesn't work for the judicial authority to be able to potentially reach an opposite contradictory decision after the event, having been party to the first decision. So the judge must determine, as a matter of fact for himself, whether this person would be entitled for retrial. So the basic submission is a simple, clear test for a judge to determine what is expected of the judicial authority is also clear, and so too is the protection clear to the requested person. And it is significant that Parliament chose to introduce the safeguard that was stronger than the framework decision, and that when the 2009 amendment the framework decision came in at the initiative of the UK, who co-sponsored it, what was called the Enhancement of Procedural Rights of Persons in its title. The UK was quick to point out that there was no need to amend our statute, as or just Burnett observed in Cretu, and that was because we're 6 years ahead of our neighbours on that issue. So the old 2002 framework decision, I've taken my lords to Article 5, which envisaged guarantees to be given by issuing member states where persons were not summoned or informed of the trial in absence, gave an assurance of a right to apply for a retrial, and that is what changed, the right to apply for a retrial to the right to the trial itself, because Article 5 was deleted to expressly strengthen the protections. And can I now briefly take my lords to the framework decision and the 2009 amendment to which is Article 2 inserted by 4A, and this is at it starts at 505, my lords' bundles, and again. If I can ask my lords just to turn to.
We've moved away now from Mr. Justice Chamberlain. I'm assuming. Yeah.
Yes, my lords. The case of Cretu actually summarises succinctly at bundle page 611 how the framework decision operates in practice in these cases, and it's paragraph 12 to 18 where that is set out under the heading the 2009 framework decision and its status. And at 18, the court, just to get to the conclusion, at the final sentence of 18, at 611, confirms the conforming interpretation principle of Popino now applies to the 2003 Act, including the provisions introduced by way of amendment in 2014. And that interpretation is then applied in Cretu at 34 of the judgment. This is page 616. And so, and one sees how it's applied with respect to subsection 5, section 20, which is simply that the question of entitled to a retrial is to be viewed.
Which paragraph are you at now? Sorry.
This is 34, Roman 4.
Thank you.
And so, so the basic 4A amendment, which applies to this case, is at page 507. And it's Article 2 that amends the 2002 framework decision by inserting Article 4A. And I don't. What it does, it provides. The rationale is it provides additional grounds on which the executing judicial authority may refuse to execute the EAW for a custodial sentence if the person did not appear in person at the trial resulting in the decision, unless the EAW states that the person, in accordance with further procedural requirements defined in its national law of the issuing member state, was either summoned in person or was aware of the scheduled trial or chose not to contest it after being served the decision. And then D is what applies here. And what it says is D was not personally served the decision, but little one will be personally served with it without delay after the surrender and will be expressly informed of his right to a retrial, in which the person has the right to participate and which allows the merits of the case, including fresh evidence, to be re-examined and which may lead to the original decision being reversed. Then we have the cumulative and second part of D, which is that he will be informed of the time frame within which he has to request such a retrial or appeal as mentioned in the relevant EAW. And then, my lords, can I invite you to read the next 3? This is Article 2, Section 3, because it follows from the procedural protection of the right to retrial that the EU is then looking forward on the assumption that that will be provided and saying, in case a person is surrendered under the conditions of 1D and he has requested a retrial or appeal, the detention of that person awaiting such retrial or appeal shall, under these provisions, until these until these proceedings are finalised, be reviewed in accordance with the law of the issuing member state, either on a regular basis or upon the request of the person concerned. Such a review shall in particular include the possibility of suspension or interruption. And then this, the retrial or appeal shall begin within due time after the surrender. So my submission, my lords, it's helpful there to see the full context of 4A, because one sees there an expectation that the retrial promised, if it is promised, in D1, following being expressly informed of that right, will in fact happen. And so it looks at the issue of detention, and because obviously extradition will proceed in custody. And so, and then can I refer, my lords, now to the relevant recitals, because they are important in my submission. And it's just going back, page 506 of the bundle, recital 6 states the provisions of this framework decision. Do my lords have 506, electronic format, page 506, at recital 6, the provisions of this framework decision amending other framework decisions set conditions under which the recognition and execution of a decision rendered following a trial at which the person concerned did not appear in person should not be refused. These are alternative conditions when one of the conditions is satisfied the issuing authority by completing the corresponding section of the AW or the relevant certificate under the framework decisions gives, and this is important in my submission, gives the assurance that the requirements have been or will be met, which should be sufficient for the purpose of the execution of the decision on the basis of the principle of mutual recognition. And so one sees here that one route is what happened in Merticariu, where the information is provided and then that's it. But if it's not available, then the purpose of the amendment was to do away with the guarantees, the particularised individual guarantees on different cases and what format they would take, to a homogenised, cohesive system whereby everyone knew what to expect, and therefore one is dealing with what it describes as an assurance that the requirements will be met. And that is, in my submission, a categorical expression of expectation. And then at recital 11, my lords, is also relevant. Common solutions concerning grounds for non-recognition in the relevant existing framework decisions should take into account the diversity of situations with regard to the right of the person concerning to a retrial or appeal. And then this, such a retrial or appeal is aimed at guaranteeing the rights of the defence and is characterised by the following elements: right to be present, merits of the case and fresh evidence re-examined, and the proceedings can lead to the original decision being reversed. And then finally, my lords, in terms of the recital number 12, just below, the right to a retrial or appeal should be guaranteed when the decision has already been served, as well as in the case of an EAW when it had not yet been served but will be served without delay after the surrender. So very clear language expressed there, deliberately chosen of a guarantee and previously the assurance. The latter case refers to a situation where the authorities failed in their attempt to contact the person in particular because he was sought to evade justice. And so there's just one more recital from the old 2002 framework decision, which sets the basic parameters at page 488 of the EF format, which is recital 8, top left of the page. Decisions on the execution of the EAW must be subject to sufficient controls, which means that a judicial authority of the member state where the requested person has been arrested will have to take the decision on surrender. So that's where the decision is to be made.
Page number, sorry?
Oh, 488, my lord. 488, this is the old 2002 framework decision, recital 8. Now, my lords, in my submission, that's more than enough already. But in case my lords would find it of assistance to have further corroborative supporting materials confirming these very, very clear propositions, more can be found confirming that in the explanatory memorandum to the 2009 framework decision amendment, which we have provided in the reply authorities at page 122, tab 4 of the hard copy bundle. And that, I note that in this court's judgment in the Assange case, there was substantial reference to the explanatory memorandum. And so it was deemed of assistance in interpretation in that case. And so the explanatory memorandum of the 30th of, it's dated. Do my lords have this document?
In your reply authorities?
Yes, it's page 122, my lord.
My reply authorities at page 122 is a document by the Council of the European Union.
Yes, my lord, and the title is actually on the following page. Does my lord see that 123 explanatory memorandum?
It's 123. I think you said 122.
Yeah, sorry, it starts on 122 as the head page with the date of 30th of January, Council of European Union, and then it explains delegations of 122. Delegation will find in the annex an explanatory memorandum in respect of the above initiative or in absentia, and explains that UK presented it. And then, as my lord observed, the document itself properly starts the annex at 123. Titled Explanatory Memorandum, and it explains that this initiative for a framework decision, bottom of 123, aims at strengthening the rights of citizens by providing a clear and consistent approach to the issue of recognition of decisions rendered, quotes, in absentia. The initiative also aims at enhancing the application of the principle of mutual recognition in the field of cooperation within the EU on criminal matters. And if I can just refer, my lords, to page 125, the objectives of the initiative, clarifying citizens' rights and enhancing mutual objective. The above-mentioned issues relating to decisions rendered in absentia cause two kind of problems. So the problems are set out that it sought to address. Firstly, an unclear situation for citizens as regards to their fundamental rights in respect notably of the framework decision on the EAW. There's also a problem of legal certainty, since this framework decision uses language that leaves considerable room for interpretation. Secondly, the divergence in the solutions for decisions rendered in absentia causes problems in the practical implementation of the legislative acts and impedes effective judicial cooperation. And the present initiative for a framework decision tries to address these problems and aims at strengthening the rights of the citizens by clarifying and rendering more compatible the criteria for applying the ground for non-recognition relating to decisions rendered in absentia. This provides for a higher level of protection of their fundamental rights at the union level and fosters legal certainty. At the same time, the initiative facilitates the application of the principle of mutual recognition. The initiative tries, in fact, to have the right balance between the two goals while taking account of the specificities of the various national legal systems. And then next title is specific objective, taking more account of a right to a retrial. And it explains, although a retrial is defined in different ways in the various national legal orders, it appears that a retrial can be defined as new proceedings on the same subject matter as proceedings which took place in absentia and so on. And then, as briefly observed above, the current state of affairs of the framework decision on the AW contains the obligation to execute a decision rendered in absentia when there is an appropriate right to a retrial in the issuing state. So that's the precondition. However, the solution in the framework decision on the EAW is not satisfactory because it provides that the EAW must be executed only if the issuing authority can provide guarantees where it's deemed adequate on the reach. So that's what was abolished with the article. That's the old Article 5 that was abolished because that was interpreted differently among member states and led to it being slowing things down. So, and then this initiative introduces in all four framework decisions an exception to the grounds of non-recognition relating to the existence of a right to retrial within a defined time frame. In the case of the framework decision, European arrest warrant, such a right to retrial may have been granted prior to issuing or be granted. So this one sees this is reflected in the recitals I've just taken my lords to. And then in order to achieve the above objectives, the initiative proceeds by direct modification of the framework decisions. And then at the top of page 127, my lords, the point I was making earlier, the initiative bears only upon cross-border cases. No harmonisation or approximation of national law is necessary in respect of domestic cases. The initiative will not lead to broadening of the scope of the and the clear and common approach to the issue of decisions rendered in absentia provided by this initiative for framework should be of assistance as a basis for future instruments of union law. And then finally, my lords, at page 128, first, the second paragraph says, secondly, the articles introduce a consistent approach to the possibility of refusing to enforce or execute a decision rendered in absentia. The standard rule is that the executing judicial authority may refuse to enforce or execute a decision rendered, and so on. And then the second bullet point, by way of derogation, it is provided that possibility ceases to exist in these circumstances. And then, my lords, at page 130, 129, Article 2 is set out, which was the basic change. At the top of 130, the explanation is given to the 4AD provision. For some reason here, it's described as 4AC. I don't know why that is, but it's obviously referring to 4AD. The new provision of Article 4AD is related to the case where the person was not served with the judge. It is more precise than the current version, which does not formally contain a ground for non-recognition, but merely provides that the executing state may surrender conditional on the existence of an opportunity for the person to apply for a retrial. So that was the old law that was deleted. The application for a retrial has gone in favour of a right simpliciter. This situation will, however, only apply where none of the other circumstances apply. And then the provision also introduces new requirements to ensure that the person will be informed of his entitlement and be given a reasonable time to exercise it. So it's very much constant and consistent with our original legislation, which is not surprising given that we sponsored this and sought to bring other, thank you, the standards, to raise the standards across the member states. Now, my lords, I hope that provides reassurance, of corroborative reassurance of the basic point which the recitals already reflected. And there's one final document in the reply bundle which perhaps of lesser importance, but it does simply, it's page 132 of this reply bundle, tab 5 of the hard copy, which simply puts on record the UK's stated public position at page 135 of this document under the heading Article 5, guarantees to be given by issuing state in particular cases. And 4 lines down in this page 135, second paragraph, quotes, the Commission report states that the UK has gone further than the terms of the framework decision by not restricting our assurance to guarantee that a person who has been convicted in absentia has a right to apply for retrial and be present at the judgment, but that we also request additional assurances. Then this, Section 20 of the Extradition Act requires a district judge to discharge a requested person where they have been convicted in absence, and it's clear they are not legally absent themselves from the trial, and he is not satisfied that they have a right to retrial. If a person is entitled to a retrial or review, they must have the right to defend themselves and so on. So it simply confirms the analysis that we've been putting before you as correct. And so, yes, and so in summary, 4A framework decision was intended to improve mutual recognition by member states, but it does not harmonise national criminal procedures. It is designed to harmonise grounds for non-recognition in surrender decisions, and this is consistent with the approach of the Dutch and the Danish courts, which I'll take Lords to in just a moment, where they do refuse to surrender. Well, they have refused to surrender to Romania, where Article 466 was not deemed to provide the necessary right in question. And so in short, the case law of the CJU confirms that the framework decision aim is one of guaranteeing a high level of protection, and that it's a task of the executing authority pre-surrender to answer self-contained Article 4A questions. An authority for that is TR at page 908 and 909, and in the criminal proceedings against LU and PH, and that is page 2125, there's an emphasis again on the high level of protection of Article 4, that Article 4A seeks to guarantee, allowing executing authorities to make the decision. And then,
do you have the paragraphs in TR?
Yes, TR is paragraph 39 on page 908, and then paragraph 51 to 55 on 909. And then in LU, it's page 2125, paragraph 50, the high level of protection, and page 2080, paragraphs 20 to 23, which is where the court refused to address the directive because it was not addressing an EAW situation, declined to provide any interpretation of 4A. And then finally, page 2081 at 32 shows it's not only the EU law that allows for it to be interpreted, but quotes, but also the context in which it occurs and the objectives pursued. And that's really what the recitals show. And so, my Lord, I'm conscious that I don't have much time left, and so I wonder if I can just summarise my core submissions. The first submission is that the plain and natural meaning of the statutory language set out in our case at paragraph 55 is the correct approach. It was the same approach taken by the court in Cretu at paragraph 27 when assessing Article 4A, 1A, Roman 1, where the natural meaning of the language was the approach used. And the court in Cretu at 27 also reinforces that approach to statutory language by noting that the interpretation is reinforced by recital 9 to the 2009 framework decision, which states in relation to the scheduled date of trial that may for practical reasons initially be expressed as several possible dates. So my key submission is that there is no ambiguity within the statute, with the essential spirit or grain conferring an unqualified entitlement to retrial. The approach to subsection 520 is deliberately prescriptive and clear, requiring the English judge to address the statutory question based on the information contained in the EAW. That must take place before surrender, and the decision is expected to be final. Mr. Justice Chamberlain made the pertinent observation during the hearing of the certification point that, quotes, the real question here is who decides that question of deliberate absence, because on one reading of Section 20, Parliament made it very clear and very straightforward. The appellant adopts Chamberlain's analysis recorded in the transcript therein, as I've taken it. And then next point is the plain and literal meaning of whether the person would be entitled to a retrial simply does not permit the judge to address whether the person would be entitled, again to quote Mr. Justice Chamberlain, quotes, to a retrial unless the courts of the requesting state decided that he was deliberately absent from his original trial. That's paragraph 23A of Merticariu. And Chamberlain's approach was consistent with the essential approach to statutory interpretation, whereby, quotes, the starting point must always be the language of the provision itself. Statute should be interpreted in order to adopt a natural meaning most consistent with its purpose. And we refer then to the equivalent cases where Section 2 of the Extradition Act was examined, where it was observed that the statutory language is not obscure and should be given its plain and ordinary meaning. So the result, my Lords, of permitting a post-surrender re-evaluation would subvert the finality of a determination by the execution court, a scheme which allows for new answers to be supplied post-surrender to the same statutory questions that an extradition court has already decided beyond reasonable doubt is inoperable, in my submission, and fundamentally unfair, and as my Lord Sales observed, in fact abusive, because the judicial authority was a party to that decision and supplied the evidence the judge decided it on. So the clear purpose of the recitals of the 2002 framework decision is to protect the fundamental rights, the fundamental trial rights of the requested person. By contrast, in my submission, a consequence of the respondent's case would be to allow a clear premise on which extradition was sanctioned, namely a right to retrial, following the careful application of a statutory protection, to be reversed post-surrender. This, in my submission, would be antithetical to the statutory protection and protections of the recitals, as Sejdovic in Italy confirmed, which I know my Lords have taken to yesterday, a failure to afford a defendant a retrial if he was not informed of his trial gives rise to a flagrant breach of Article 6. That is why the statutory protection pursuant to Section 25 was intended to be simple, unambiguous, robust, and to guarantee a meaningful protection. It also went further than the 2002 framework decision right, protecting a right only to apply for a retrial, which is all that would happen in this case. So Parliament chose to provide for additional specific procedural rights so that the court could be assured the retrial would be meaningful. Such was the importance of the substance of the retrial. See section 20, subsection 8, where the specific elements are set out. Well, my second submission is that the evidence of the judicial authority simply fails to meet the section 20 test of providing the appellant with a right to retrial. And we now know that there were multiple attempts to provide the necessary answers. Because it wasn't provided in the pro forma 4A framework decision format. And what was explained as a very quick and easy question was just not addressed. There was, contrary to the specific objective that extradition should be dealt with swiftly, a failure to engage. It was the respondent's conduct that prevented the rapid decision that should have been made on the AW in terms of these failures to engage with repeated questions properly posed by the CPS and the judge. So the point is that the correct application of 25 is, and 4A of the framework decision doesn't create a cumbersome or onerous system, but only that those requirements are addressed. And so,
sorry for interrupting, but I was, one of the arguments raised by the respondents is based upon the 2016 directive,
yes,
which is directly applicable in Romania. And at some stage, for my own part, I'd be very grateful for your submissions about that.
My Lord, I'll endeavour to address that as best I can. And I hope I've touched on it already in submitting that that the purpose of the framework decision is to ensure these issues are determined at the pre-surrender stage by the executing judge. And just as the protection of section 20 and 4A was introduced, notwithstanding Article 6, the directive really falls into the same category of this is yet another potential domestic provision which isn't intended to replace the cohesive, exhaustive framework of 4A and doesn't address the requirements of section 20. And so, yes. So, returning to submission 2, the evidence simply wasn't there. Chamberlain himself observed, this is electronic page 49, that at paragraph 26 of his judgment, that there is no evidence to indicate that the retrial would be granted if the appellant requested one. And then my submission is you simply follow the Cretu approach at 35. You focus on the AW. Does it contain a necessary statement such that one of the 4 exceptions from the framework decision 4A is established? And as a general rule, the executing court is bound to take the statements and the information at face value. And yes, and the reference point is 4A. And so this EAW simply didn't establish that the defendant was deliberately absent and failed to provide for an assurance of a retrial. On any view, the EAW was not clear. It is submitted that DJ therefore fell into error, uncorrected by the administrative court by citing a partial extract from Cretu to seek to cure what was fundamentally defective EAW. Because he overlooked the key guidance in Cretu, which required the court to focus on the adequacy of the information itself. And so I think I've probably said enough about that submission, but it's all fully developed in our case. And the next point is that Article 466 only allows for a qualified right to a retrial. It may assist the court to consider the terms of 466, which I've taken you to already. That the law it is referenced. Yes, pages 2528 of the authorities. Authority 100, where the official translation is provided, and yes, and do my Lord see 2528? It's that the 466 in fact stipulates that the appellant cannot even apply for the criminal proceedings to be reopened if he was not tried in absentia. And so the language is person with a final conviction who was tried in absentia may apply for criminal proceedings to be reopened. So this is a point that I don't think was made previously, but it's obviously significant that even if taking the respondent's submission to be correct, which we submit, the law shows it to be old bad law, that it's simply an application for a retrial that has to be satisfied. On the Romanian law, he can't even make the application unless he's deemed tried in absentia, and we see, as I explained before, that he can't be deemed tried in absentia because he doesn't meet the conditions of Section 2. So he's disqualified even from making the application itself. And then, my Lords...
Can you just remind me, we were looking at Article 466 at page 378 before.
Yes.
Whose translation was that again?
That was provided, well, it was never served in the extradition hearing.
So it wasn't served, but it was provided by the Romanian
It was sent.
authority.
My Lord, yes, it was sent, I think, sent by the liaison magistrate, I think, to the CPS, but not served or advanced at any stage of the proceedings until we...
And does it correspond with this? I mean, you've called this an official translation. I mean, in fact, it's...
I believe it does, yes.
Right, okay.
So I wondered why you'd shifted from one text to the other. But
Well, it was only because this was served. This translation was served, whereas the other one wasn't. So I thought you may want to see what was, in fact... Sorry, when I say this was served by the appellant on appeal. The official translation was served to by the appellant on the High Court on appeal, whereas the other document wasn't served by anyone. So I just thought you may want to see the actual official translation.
Thank you. But it's essentially the same point that the appellant on the answers given in the EAW would not meet paragraph 2 of the article and therefore wouldn't be allowed to apply.
Yes, my Lord, with the additional point, which we hadn't set out before, and which the language of section 466 clearly establishes in my submission, which is that it doesn't even meet the respondent's case, which we submit wrong, that it's simply an application that must be allowed for, because the wording of sub 4661 is that it's only people who are tried in absentia that may apply. So it disqualifies, essentially, anyway, it's just another way of approaching the wording of 466. And so...
You're saying on the face of it, they wouldn't be allowed to apply?
Well, according to that language of there, that it's only a person with a final conviction who was tried in absentia that may apply for the proceedings to be reopened. Therefore, because he was not tried in absentia, then on their own evidence, he won't be allowed to make the application. That's what it says.
Yes.
But the real point, my Lord, is that the respondent didn't provide any evidence about the terms of Article 466 of the Code in the context of these proceedings at any stage. This was, as I say, was provided by the appellant to the High Court. But the real problem, as identified, is that the potential for a retrial via 466 is in fact susceptible to a post-surrender reassessment of the facts that may result in the retrial being refused. The same facts, the same determination, the same issue being revisited. And so...
Can I just ask, sorry, just so I can get it clear in my mind, what's the nature of the appeal to the High Court? And you say that this was introduced as fresh evidence in the High Court, introduced by the appellant. Is there a complete right to introduce new evidence in the High Court? What's the nature of the appeal?
Well, no, there's not a complete right. My Lord, an application, so where fresh evidence is being introduced to an appeal court, there has to be an application, and it has to meet the Venevesi test. It has to be material that wasn't available before, wasn't reasonably available to the parties before, and so that is, and it has to be determinative of the issue. It has to. That's a two-stage test of Venevesi.
So was such an application made to introduce this as new evidence?
Not as far as I'm aware, my Lord.
Right.
Can I confirm that position? But my understanding is that there was no formal application made. But the real point is that the burden's on the judicial authority to make its case.
I understand all of that. I just wanted to understand what exactly is the status of this document.
Yes. So the answer is in the round that reliance has been placed on other judgments that cited the relevant law, as happened in the Magistrates' Court and the High Court, and so that's. But I've given my submissions as to why that's not the correct approach, and caution should be exercised. My Lords, can I then just very briefly refer my Lords to the reference to the Dutch decision, to the decision of the Court of Amsterdam, which is bundle page 2530, and it provides another example of the Dutch executing judicial authority dealing with a conviction in absentia in Romania and deciding the same framework decision 4A test of whether extradition meets the test and whether there'll be a satisfactory entitlement to a retrial. And what's interesting about this is that page 2532, one sees the Romanian authorities presented to the Dutch court the following evidence. And if I just refer, my Lords, to third paragraph of the italics, the convicted person tried in absentia has the possibility to request the reopening of the criminal proceedings under 466. This legal text regulates the possibility for the convicted person to request the reopening of the criminal proceedings if he wishes to do so, and should be considered only as an additional guarantee on the right to defence, not as an appeal. And then the next paragraph is important, as it says, this is the Romanian authorities publicly informing the Dutch court that the text of the law in question only regulates the possibility for the convicted person to make an application, which does not guarantee the reopening of the trial, as a decision on such application is left to the discretion of the judge hearing the case. He will give his decision on the basis of the evidence submitted by the convicted person in support of the application. And at the following page, 2533, the Court of Amsterdam dealt with this by firstly summarising the position of the public prosecutor's office, so the equivalent of the CPS in Holland, adopted the position that the supplementary information I've just taken you to appears to concern an unconditional guarantee of trial, but acknowledges that a certain scope for doubt still exists in this regard. And then the opinion of the court is 5 lines down. For this reason, the court is unable to determine, using this information, whether there is an unconditional right to proceedings to have a default judgment set aside or appeal proceedings as referred to in section 12D OLW. Now, we've provided that Dutch legal provision, which is equivalent of our Extradition Act, in the reply authorities at tab 1, which is page 3 of that bundle. It's an official translation. And so, it's in my suspicion, notable that the Romanian authorities there are being candid about the deficiencies of 466 and how it doesn't meet the framework decision test, and that the Dutch court relies on that to determine that the test wasn't in fact satisfied, and that the 4A test is adopted by the Dutch domestic law. So it's really the same, we're dealing with the same provisions. So, my Lords, the next submission 4 is a conforming interpretation point. And it's simply that, consonant with Cretu, we invite the court to determine section 20 consistently with the framework decision. And no substantive part of 4A framework decision dilutes the retrial entitlement that is at the heart of section 25. In the event that it did, to read in words that have been abolished by the EU law would be perverse and contra legem. So the only procedural limitation that 4A placed on a retrial is the time frame aspect.
So just in terms of the timing, as I understand it, the Extradition Act, section 20, comes first, and then you get the 2002 framework decision, which falls for implementation after the Extradition Act comes into effect. Is that right? And
yes.
Then in 2009, you get this framework decision.
Yes, I think that the 2002 framework decision, I believe, will have preceded the 2003 Domestic Act of Parliament. So it's dated the 13th of June 2002.
And was it required to be implemented before then?
Yes, I believe it came into force as of that date, but perhaps I can confirm that, whereas the statute will have followed.
Right.
The following year. And so, yes. So, my Lords, my submission is that on BP, firstly, it would be helpful if my Lords observed some of the facts of BP, because...
Yes, the 2002 framework decision, Article 35, entered into force on the 20th day after its publication, and in the journal, and was dated June 2002. So the journal publication date seems to be the 18th of July 2002. So you're right that it was in force before the 2003 Act.
Well, I'm obliged.
But yes, perhaps more importantly, you're returning to the case.
Yes, so this is a judgment that was relied upon to decide the issue against the appellant. And so it starts at EF, page 586, and it would be helpful just to briefly observe the facts at page 587. Paragraph 5, the warrant states in BP that the appellant was tried in her absence, quotes, but she delegated a chosen defendant, lawyer Octavian, who ensured her defence. After conviction, she applied to the High Court, but it affirmed her sentence. And in paragraph 7, over the page 588, of Mr. Octavian, the Romanian lawyer, the appellant said in evidence that neither she nor her family ever instructed him. Instead, he represented her ex-husband at the trial. She explained away information from the Romanian authorities that her mother had signed the summons on the 9th of December 2013 for the application to the High Court of Cassation and Justice. District Judge Purdy adjourned the hearing, and further information dated the 30th of October 2014 was obtained from the High Court in Romania. It set out that Mr. Octavian's explanation that the appellant's parents-in-law had employed him as a defence lawyer, and that the appellant's mother was present at almost every hearing of her daughter's trial, and that he sent certain documents as requested to the appellant's lawyer here in Britain. And then over the page at 590, paragraph 19, as one of his findings of fact, the DJ stated that the appellant was not deliberately absent from her Romanian trial. As to Mr. Octavian, the judge found that, strange as it might seem, she did not know that he was acting for her, and his instructions seemed to come from the parents-in-law, who did not like her and wanted their son to separate from her prior to the proceedings. Perhaps Mr. Octavian explained, perhaps Mr. Octavian himself was willfully misled, said the district judge, but he was not acting for her with her knowledge and consent. her mother did attend court, but he was unable to infer, despite the express information from the authorities, that by attending, she really understood what was going on. So it's obviously significant that this judgment arose on facts whereby the requested person's family were attending the trial itself, and the Romanian authorities served evidence as to instructions deriving from them. And so paragraph 31, page 592, the letter of the 22nd of September 15 refers to the admission on any application for a retrial in Romania of the proof of evidence that the appellant presented before the English court. The letter also states the appellant's mother signed Mr. Octavian's legal assistance contract. It was not possible for the Romanian court to state at that stage, prior to any request for retrial, whether the findings of the English court were mandatory. And one sees from the letter itself that the lawyer Octavian kept connection with the lawyer from England during the entire trial from Romania, which is, in my submission, a significant factual feature of this case, that the Romanian defence lawyer and the lawyer in this country were in communication at the time, and Mr. Octavian has shown that he has sent to the lawyer from England of the appellant documents which have been requested by her. Therefore, the appellant may not assert that she was unaware of the trial. The letter adds the appellant may make an application for retrial under the Code of Criminal Procedure. She'll be able to point out in her defence the evidence she owns. And so, if my lords refer then to the key paragraph 44, Mr. Justice Cranston said, to my mind, the appellant has an entitlement in this case to a retrial in Romania. Article 466 provides for that. There is no discretion in the Romanian court to deny that right. Well, we know from the materials before this court that that's not correct. Admittedly, the Romanian court could decide the appellant had appointed Mr. Octavian to represent her through her mother or otherwise, and therefore does not qualify for a retrial under 466. But that is a procedural step, as it was described in Nastase. Well, in my submission, it's clearly more than a procedural step. The time limits, making the application within 10 days or 30 days, can be properly characterised as a procedural step. And there was clear authority from the English courts to that effect. In Nastase, Rafferty held that although the Italian court could theoretically refuse a retrial where it was satisfied that the requested person knew of the original proceedings and voluntarily absented himself, that was a procedural step which did not detract. And then Mr. Justice Cranston explains that in this case, the Romanian Judicial Authority had stated that in making the decision under 466, it will take into account the district judge's conclusion that the appellant did not know Mr. Octavian was acting for her, and that it seemed that her mother was unaware of what was going on, but it is not mandatory. And he says nothing more can be required of the Romanian authorities. So it's another distinguishing factual feature of this case. The Romanian authorities served evidence. They would take into account the English judge's findings on these issues. And so yes. And then it says nothing more can be required of the Romanian Judicial Authority. We work on the basis of mutual trust between convention states, especially if EU members. The Romanian court finds that the appellant had not instructed the lawyer she is entitled under their law to a retrial. And so sorry. I understand I'm running out of time.
Well, you can use up your reply time if you want, but anything from now on is eating into your reply time.
Okay, well, that's most helpful, my lord. I'll be as quick as I can. So firstly, as I pointed out, it's wrong to say that there's no discretion in the Romanian court to deny this right. In my submission, denying the right based on an application of 466 is not a mere procedural step.
The point must be, you must say that paragraph 44 is simply wrong. Yeah. It is totally inconsistent with the submissions that you made this morning.
I do, yes. And I was just going to go on to expand by an assumption that Romanian law will provide a right to retrial doesn't meet the statutory test. Yes, and I think my lords have my points. The fact that Romania transposed 4A into its law does not matter if the requested person fails the test to be afforded a retrial based on the evidence before the English judge who has to decide the issue. And the fact of the transposition of Romanian law, the framework decision made no difference to the decisions of the courts in the Netherlands, who found that the Romanian law failed to provide the necessary guarantee of a retrial. And so, in summary, in conclusion, my lords, my final submission is that the correct approach, whereby there is finality to the executing court's answers to Section 20 questions, is the only approach that is consistent with the statutory scheme. The interpretation of the statute in context of the legislation as a whole is a long-established principle, and the context must always be identified and considered. The underlying purpose of the Act and the framework decision is to create a simplified and accelerated procedure based on mutual recognition and confidence. That simplicity and efficiency of the scheme is jeopardised if the requested person is not given sufficient information at the earliest stage of the proceedings. And it is clear from the EAW pro forma that the intention is that the judicial authority addresses what is a simple binary Article 4A framework decision question at the point at which the EAW is prepared. As an additional safeguard, there's the ability for the executing judge to seek supplementary information, as happened in this case, later in the process, before concluding the substantive hearing. So these are the designated opportunities for the judicial authority to advance the case on deliberate absence and on retrial rights. Even Article 15.2 requests for clarification are to be treated as a last resort, quotes, and in exceptional cases, quotes, end quotes, as a matter of urgency. So it's not unduly onerous on the JA to provide simple answers to these questions, where the detail will inevitably relate to events in the past within its knowledge by virtue of it being a party to the conviction in absence. Article 4A and the updated pro forma further reduced the burden on the JA by introducing a short form way of meeting the test. So, nevertheless, the scenarios are carefully prescribed with good reason because the fundamental rights and the liberty of the individual are at stake. So, the status of the person as accused or convicted, and if convicted, whether or not there's to be a retrial, are relevant to other statutory considerations. And the appellant submits that mutual confidence and respect would be undermined by a requesting judicial authority redetermining the executing judicial authority's evidential factual decisions on issues as fundamental as deliberate absence. And following surrender, any requested person should be able to rely upon the findings made by the executing court in proceedings that both the requested person and the judicial authority were participating in. And so by placing the strict evidential burden on the judicial authority and requiring the decision from the executing judge on the statutory question, the statutory scheme envisages the person will receive a meaningful protection of the retrial right. The respondent's interpretation, allowing for a post-surrender de novo review of the Section 20 question, generates a lack of finality that undermines the entire scheme, introduces an extra step that is only needed if the judicial authority fails to advance its case adequately when drafting the request or when opportunities are given to supplement it. So I submit that the word entitled in subsection 5 should be interpreted in accordance with the definition in the case of Bohm, requiring the right to a retrial to be automatic, not subject to the exercise of subsequent discretion. Article 4A 1D1 supports this assertion, and by ticking the appropriate box of 3.4, the JA does give an assurance that the requirements have been or will be met, pursuant also to recital 6. So this is a forward-looking step in compliance with the terms of 25 by removing the possibility for discretion to be exercised by the court in the requesting state. And so, I place emphasis on the fact there was an express decision to remove the previous law, which allowed, under the framework decision, only for the opportunity to apply for trial. So even the European instruments now recognise it has to be the right simpliciter. So, yes, my lords, those are my key submissions. I'm conscious I've run out of time. But if there are any other matters I can assist you with at this stage, I'd be happy to do so.
Yeah, thank you. Thank you very much. You've used up an extra 5 minutes, so that will come off your reply time.
Understood.
Yes.
Thank you, my lord. I have to begin by unpicking the very fundamental error of fact and of Romanian law that you've been led into this morning by Mr. Cooper's repeated bold statement, Lord Burnett's words, that it is absolutely clear this requested person can't have a retrial in Romania. I think I've identified the genesis of that, and it was a few words in the appellant's case. At page 34, paragraph 16 of his case, it is not a position that has ever been articulated in terms before, but it may be that the error starts at paragraph 16, which reads, "The agreed position, therefore," and this is before the lower court, "was that EAW failed to prove presence at trial via a lawyer or deliberate absence, and these are the odd words, failed to guarantee a retrial." And the reference there is to the statement of facts and issues at paragraph 8 and to the judgment of Mr. Justice Chamberlain. So you then go to the statement of facts and issues, which Mr. Cooper and I drafted and redrafted between us, and you look at paragraph 8, and actually what is agreed and what was conceded was that the information in the EAW didn't demonstrate that he was either present at trial physically or through a lawyer he had mandated, nor was he deliberately absent. That is correct. I cannot establish, and nobody could establish in the lower court, that he was deliberately absent, which is why we're in section 20, subsection 5 territory. And it is unclear and could not therefore have been established to the requisite standard that he was either physically present or present through a lawyer he had mandated. However, the words that it was agreed that Romania had failed to guarantee a retrial is not supported by the footnote that appears immediately after it. Can we please look at the EAW at page 212 of your bundle? It's behind tab 8, and I'm already in the wrong bundle. This bundle is slightly confusingly double-paginated, the core documents. It's either tab 8, page 212, or it's electronic page 330.
I think we were looking earlier at 330. Yeah.
Yes. Thank you, my lord. The entire problem in this case has arisen because of the ambiguity on that page and on the following page. So, on page 330, the requesting judicial authority put a cross against the pro forma words, which are a direct lift from Article 4A1B. Being aware of the scheduled trial, he had instructed a lawyer who was either appointed by the person concerned or ex officio to defend him at the trial, and was indeed defended by that lawyer at the trial. And as required by the pro forma, when you turn the page at 213, and this again is part of the pro forma, against paragraph 4 in the middle of the page, if checked the point 3.2, please provide information on how the relevant condition has been met, to which the answer, and this is the bit that is specifically inserted into this EAW by the judicial authority in relation to this requested person, the defendant, Bogdan Ionit Merticariu, was not present in court during the trial. He was represented at the hearings by public defender appointed by the court. You then get, on the third page, 214, electronic page 332, something which, I entirely agree with Mr. Cooper, is not part of the pro forma, but was added for the assistance of the lower court here. Specify the legal pledges according to Article 466 of the Penal Code, reopening criminal proceedings in the case of an in absentia trial of a convicted person, paragraph 3, and then you get the pledge that upon return, the time frame provided for any application to reopen is, I think it's 30 days. So, but anyway, the point is that it doesn't begin until he's brought into the country. So there's no fear that it's already run out or running out. It begins from the date when, following their bringing into the country, they receive the conviction verdict.
Is he entitled to a retrial?
My lords, the whole point is we don't know at the moment. What he is entitled to and has is a right to apply for that, subject to the provisions of the Romanian Code. And my lord, I'm sorry if I sound frustrated. I will, I assure you, come back to this. May I just take you through?
Certainly, but we're going to proceed on, well, certainly for my part, I'm proceeding on the basis that hasn't got an entitlement to a retrial, he's got an entitlement to apply for a retrial.
Well, that itself depends on the definition of those words. You will see in a moment that Mr. Justice Dove said, in his view, he had an entitlement to a retrial, subject to the procedural requirement that he brought himself within the category of people who could exercise that right.
I must say I struggle to see that described as a procedural issue. I mean, there are procedural issues like timeframes and filling in of documents, but isn't it a substantive requirement? It's a substantive condition that he comes within the terms of Article 466. I mean, in your own case, you speak about procedural, but you also speak about substantive. Sometimes you seem to recognise it as a substantive condition. What is your position?
Well, I don't think I used the word substantive, and it's certainly not the words that's used in any of the authorities that have been over the last decade, to which I'm going to have to take you. But if I have to prefer one piece of information over the other in the EAW, then obviously the most obvious thing is not the pro forma tick, but the information that's explicitly put into the EAW by the independent judicial authority in Romania that says he is a person who was not present and represented by a public defender. That means he is entitled in Romanian law. If I'm entitled to interpret 466, he certainly doesn't fall within an exception. He is absolutely going to be entitled to a retrial. There's no suggestion he was deliberately absent. There's no suggestion in this case that he was informed in person or in any other way. There's no suggestion he was present.
Well, there is the suggestion because box 3.2 was ticked.
Well,
so it was the suggestion made by the judicial authority, and it's why it has puzzled me throughout why no further questions were asked of them about 3.2, and I put the question earlier about precisely how that point was essentially thrown away, it appears, on the 27th of February.
Yes, my lord, I accept that. I accept there is that suggestion because it was ticked. Absolutely. Yes. But in terms of
Well, forgive me, Ms. Malcolm, it's more than a suggestion. It was the basis upon which the Romanian judicial authority was inviting the courts of this jurisdiction to proceed.
It was part of that which required to be expanded upon and explained, providing the information of how the condition was met. And under that paragraph, it says that he's represented by a public defender and not by a mandated lawyer. Because he would have to, in order to come within 3.2, he has to have instructed the lawyer, mandated it, which is a reflection, or which is reflected in Article 466 of the Romanian Code, a retained counsel, which plainly means counsel whom he had instructed.
Well, that doesn't seem to be the view of the Romanian Judicial Authority when they tick box 3.2.
And also, I mean, is it really right for us in these proceedings to be trying to construe and give effect to a provision of the Romanian criminal code? I mean, usually when matters of foreign law are approved in our courts, you don't just get given the text of the law, you get an opinion from a qualified expert saying how it's applied and what it means, how it works in practice.
My lord, I accept that problem, and it's exactly the issue with my friend's argument. His suggestion is that in every single one of these cases, that is what is going to happen, because it's the court in this country that has to predetermine what is going to happen upon an application in Romania. So that in every case...
I rather thought his submission was if the relevant box of a right to a retrial is not ticked in the EAW, the requesting state is immediately on the back foot because they are not asserting or claiming that there is a right to a retrial. And we know from section 20, subsection 5, the right to the retrial is what has to be looked at. So it's not so much for the requested person to prove what the law is in the other state as for the judicial authority of that other state to tick a box which guarantees a particular state of the law in that state.
The genesis or the basis of his submissions, is that in answering Mr. Justice Chamberlain's query as to where it's decided, in every case it has to be proved beyond reasonable doubt in this country. So I accept the burden is going to be on the requesting state, but that means that for every case, certainly every case where there's any ambiguity or concern, it's going to be for the requesting state to prove by expert evidence, by calling the understanding of a lawyer who still, and I will get to this, can't bind the judge in the foreign state, but by calling an expert lawyer to say, in my view, based on the instructions that I have received or the information, the evidence that I've listened to, and based on what is in the specific EAW, there will be a right to retrial.
But you didn't do that, did you?
No, because...
So if the onus is on you to establish that there is a right to a retrial, you don't tick the box in the EAW, you don't call evidence to show that there is a right to a retrial.
I'm sorry, what I meant is that's what Mr. Cooper is saying has to happen henceforward.
Well, is it?
That is the clarification.
I'm so sorry to interrupt you, but you've prefaced your answer to my lord by saying in cases of ambiguity. So step one is that one would hope that the EAWs are competently completed. But then step two is that the judicial authority here and on the Luxembourg authorities, we see its vigour, can use Article 15.
Yes.
And so the simple question here was, is he entitled to a new trial.
Yes.
The answer could have been, we now accept that he didn't know about the trial, if that is the case, and therefore he's entitled to a new trial. But on 4 occasions, or was it 3, the statement was he's entitled to apply.
It was 3 occasions.
3 occasions.
Yes. May, August,
yes,
and September. Yes. May I explain, or may I just continue for a moment? The Form A that came in specified he had a right to a retrial. There was clear ambiguity in the European arrest warrant. It would be an ideal world if every European arrest warrant were properly and clearly filled out with any ambiguities. This is not an unusual example. If one has to choose between one or other piece of information, then the logical thing is to choose the one that's filled in relation to the requested person. And my lords, I should explain, if I sound a little clipped, it's because what Mr. Cooper has represented to this court this morning involves everybody on this side of the court being knowingly aware in promoting an abusive process. That is to say, promoting one version before the lower court in this court in order to obtain an extradition order, knowing that when they go back to the foreign state, there's going to be a different answer put in front of the Romanian court. And that is simply not the case.
Where do the Romanian courts say that?
Sorry?
Where does the requesting judicial authority say, we now accept? Well, it's the same question that my Lord Burnett asked. We now accept that he wasn't present at the trial. Where do they say that?
Oh, well, they say he wasn't present at the trial in paragraph 4.
I know.
Deliberately absent,
yeah.
I think is the...
Yeah.
But the answer to that is that repeatedly, and in my submission absolutely correctly, they say it is not a matter that we can prejudge before a hearing. This is a matter that has to go before the hearing. 466, 467, 468, 469 provides the procedure, and I think contrary to something else Mr. Cooper said, for a proper hearing in the courts in Romania at which the entitlement to retrial is decided, at which all interested parties are present and able to put before the court whatever is necessary. And the Romanian authorities, and it did start with Bohm, but it's the case all the way through, are particularly careful that neither the Ministry of Justice nor a public prosecutor nor an official at the individual court binds an independent judge in advance of the hearing. The Italians, as you will see, are a little bit more relaxed in the authorities about being able to say, well, it's so remote that they won't grant this, or we can give you an assurance that they will grant this. But the entire basis of the European arrest warrant, which was brought in answer to the very recent question, the statute, the extradition statute, was already in the course of negotiation when the framework decision was promulgated, the 2002 one. It was then brought into force, or the drafting was finalised and brought into force with enormous speed because it was just after 9/11.
Can I ask you two questions? I just want to take you back because I don't think you quite fully, in a sense, continue to the end of the submission that you were making. So I think you started off by saying, I want to knock on the head the idea that it's absolutely clear that in Romania there is no entitlement to a retrial.
Yes.
And you would take, and as I understand it, that argument is because of the words in 4662, the convicted person who had appointed a retained counsel.
Yes.
As opposed to, so the distinction you're drawing is someone who was appointed by the court to represent.
Exactly.
Yeah. Okay.
Ex officio.
So that is your point, is it, as to why we cannot be sure that there is no entitlement to a trial, contrary to what your opponent has said?
Yes, because the EAW specifies he was represented at the hearings by the public defender appointed by the court. The only exclusion for a right to retrial being granted is where the convicted person had appointed a retained counsel.
Yes. So that's the point. I mean, yes. I think it's right to say that one might think that that is open to interpretation, but we haven't got that interpretation in front of us. It may be that under a Romanian law, what is meant by appointed or retained counsel includes a court-appointed counsel. But that's neither here nor there, because I think you say we can't be sure of that, we've got no evidence on it, etc. We can put to one side the idea that it's absolutely clear that there's no entitlement to a retrial.
Certainly that is the consequence, yes. As to whether or not, as to the meaning of retained counsel, the distinction is capable at any rate of some elucidation by all of the Article 6 decisions. There is a substantial difference between mandating, instructing a barrister, counsel, counsel, whoever it is who pays for it, and that's an entirely separate thing, as it would be in this country.
Now, the second point I wanted to just ask you about is that, as I understood your answer to my Lord Stephen's question, you said that the question of whether there is an entitlement to a retrial will be decided by the Romanian court.
No, the question.
I think that is what you
that's
said.
what I. Well, then I was in error. The question of whether a retrial is granted is for the Romanian court. My submission is, and has been throughout, that this appellant has a right to a retrial, as so defined by the authorities, and as a matter of logic and practice across the states.
Okay, so you say whether a retrial will be granted is a matter for the Romanian court.
Yes.
You're saying that is consistent with saying that there is a right to a retrial.
Yes, I mean, as I read your case, you interpret the entitlement to a retrial to be met if you can establish that the requested person has a right to apply for a retrial in Romania.
I do, and that's not my invention.
No,
in answer to Lord Burrow's question,
you'll be developing it after the shorter adjournment, no doubt. But all you're asking us now to do is to put to one side consideration of a submission that Article 466(2) is slam dunk, and this person is not entitled to a retrial.
I
fully understand why you asked for that, because we are not here to interpret Romanian law. We have no expert opinion evidence on it.
But also, if that were the answer, and I were conceding that, none of us would be here.
Yes.
But may I send you away with one further thought to the short, and I will be very short. But in answer to my Lord Burrows, it's not just that Mr. Cooper is asking you to overrule BP. He's asking you to overrule, and I'll have to go through these, the Divisional Court in BP, the Divisional Court in Nastasi, the High Court of Justiciary in Scotland in Deja, the Lord Chief Justice, as she now is, in Dumitraki, Mr. Justice Dove in Taranenko, the Divisional Court in Goluska, and Mrs. Justice Gloucester and Zeka. In fact, every single High Court case that has been decided on this provision since 2012. And he misstated Mr. Justice Chamberlain's ruling to say that there were only 2 cases against him. Mr. Justice Chamberlain rightly doesn't use the word only. there are at least 7, and despite the fact that they're in our case, and despite 2 runs at his reply over the last 48 or so hours, none of the 5 latest cases have ever even been mentioned by him. And, my lords, I'm maybe a minute over, so I will stop there and sound less
You
clipped.
wanted to get
I
back
do.
before lunch.
I undertake to sound less clipped after lunch.
Mr. Markham, thank you very much.